Oh my God, you've ruined my 40 years of hard work.
There is a moment in every courtroom, and if you have ever sat inside one, you already know what it feels like, where the entire room goes still. Not quiet in the way a library is quiet. Still. The kind of still where you can hear the person next to you swallow, where the clock on the wall sounds like a drum, where every person in that room understands simultaneously that what is about to happen cannot be undone. That moment happened on a Tuesday morning in the fall of 2019 inside a probate courtroom in Columbus, Ohio. A judge was holding a single sheet of paper, handwritten, folded twice, stained faintly at one corner as if it had been pressed against the bottom of something metal for a very long time. The judge read it once, then he read it again. And when he looked up at the family seated across from each other on opposite sides of that room, his expression said everything the law would spend the next several months trying to put into words. What you are about to hear is a true story. It is a story about a mother named Dorothy, a woman who spent 40 years building something worth leaving behind. It is a story about the children she raised, the trust she extended, and the moment that trust became the most dangerous thing she owned. It is a story about a will that disappeared, a will that appeared in its place, and the impossible question that followed. How do you steal from someone who already knew what you were doing? How do you cover every track, forge every signature, and convince an entire legal system that a woman freely gave away everything she had worked for, when that woman had been quietly, carefully, methodically leaving a trail of evidence that only one person in the world was meant to find? Before this video is over, you will know exactly what was written on that piece of paper the judge could not stop reading. You will know who wrote it, when they wrote it, and what it cost them to write it. And you will understand why a single handwritten line, 12 words, barely legible, pressed into the bottom of a fireproof lockbox, was the only thing that stood between justice and a lie that almost became permanent. But someone made one mistake, and that mistake was hiding in plain sight the entire time. Who gets everything, and who was left with nothing? Before we go any further, we need to establish what was at stake, because this story only makes sense when you understand the full weight of what was almost lost. Dorothy Mae Henderson was 73 years old when she died on the morning of September 4th, 2019, at Grant Medical Center in Columbus, Ohio. She left behind a paid-off house on the east side of the city that she had lived in for 31 years. She left behind a savings account, a small investment portfolio, and a collection of jewelry she had been adding to since her 20s. In total, her estate was valued at just over $420,000. That is not generational wealth by most definitions. But for a woman who had worked as a school cafeteria manager for 22 years, raised 3 children largely on her own after her husband passed, and never once asked anyone for anything she could not earn herself, $420,000 represented an entire life. Every decision she had ever made with money, every sacrifice, every year she had packed her lunch instead of buying it and driven a car with 200,000 miles on it instead of taking out a loan. It was all there, sitting in that estate, waiting to go to the people she had chosen. The question, the one that would consume the next 14 months and eventually land in that Columbus courtroom, was simple and devastating. Were those the people who actually received it? The will that Dorothy's daughter Renee produced within 72 hours of Dorothy's death said yes. It said that Dorothy, of her own free will and sound mind, had chosen to leave the overwhelming majority of her estate, the house, the savings, the investments, to Renee alone. Dorothy's son James, who had driven his mother to every chemotherapy appointment for 18 months, received a small cash bequest. Dorothy's youngest daughter Carol, who lived in Atlanta, received nothing at all. When James sat in that attorney's office and heard those words read aloud, he did not cry. He did not argue. He sat very still for a long moment, and then he said 4 words that would eventually prove to be the beginning of everything. That is not right. He did not mean it as a legal claim. He meant it the way you mean something when your body knows the truth before your mind has caught up with it. He meant it because he had sat with his mother 2 weeks before she died, and she had squeezed his hand and told him she was worried. And he meant it because 3 years earlier, he had helped her sit down with an attorney and write a very different kind of will. So here are the questions this video is going to answer. Where was the will Dorothy actually signed? Who decided it needed to disappear? And what was inside the lockbox that Dorothy had kept in her bedroom closet for 30 years? The one that was missing from her house before the funeral was even over? The family behind the house on Maple Ridge. To understand what happened to Dorothy Henderson, you have to understand who Dorothy Henderson was. And who she was cannot be summarized quickly because she was the kind of person who resists summarizing. She was born in 1946 in Birmingham, Alabama, the second of 5 children in a family that did not have much but understood deeply the value of what they did have. Her father worked in a steel mill. Her mother took in laundry and ironing for neighbors and never once complained about it within earshot of her children. Dorothy grew up understanding that dignity was not something that arrived with money. It was something you carried. She moved to Columbus in 1971 when she was 24 years old, following a cousin who had found work there. And within 2 years, she had met and married Robert Henderson, a quiet man who drove a delivery truck and coached youth basketball on weekends. They were not a dramatic couple. They were a steady one. The kind of marriage that does not produce great stories because it is built on the unglamorous architecture of showing up and working and choosing each other on the ordinary days when there is no particular reason to choose anyone. Robert and Dorothy had 3 children over the course of 7 years. James was the oldest, born in 1974. Renee came 18 months later. Carol, the youngest, arrived in 1981, and Dorothy always said Carol came into the world laughing, which was either a blessing or a warning depending on the day. Robert died in 2003 from a heart attack at the age of 57. He was at work when it happened. Dorothy got the call on her lunch break. She drove to the hospital, stayed until the doctors had told her everything there was to tell, drove home, made dinner for the 2 children still living at home at the time, and did not cry in front of them until weeks later, alone in the kitchen, when she thought everyone was asleep. James heard her. He was 29 years old, and he came downstairs and sat with her at the kitchen table, and neither of them said much. That night was the beginning of something between James and his mother that went beyond the ordinary bond between a parent and a child. He had seen her in the moment that broke her, and she had let him. That does not happen easily. It does not get forgotten. By the time Dorothy retired from the school district in 2012, her children were scattered in the particular way that American families scatter. James had stayed closest. He lived 40 minutes away, worked in logistics, was divorced, had 2 teenage kids he saw on weekends. He called his mother every other day and had dinner with her at least twice a month. Carol had moved to Atlanta in her late 20s, built a career in healthcare administration, married a man named Dennis, and visited Columbus twice a year at Christmas and in the summer. The relationship between Carol and Dorothy was warm, but geographically thin. They loved each other in the way you love people when distance has turned the relationship into a series of highlights rather than a continuous thread. And then there was Renee. Renee was the middle child, and she had spent most of her adult life living the unresolved story that middle children sometimes carry, slightly outside the gravitational pull of both the oldest and the youngest, performing closeness rather than feeling it, always in the process of renegotiating her place. She had lived in Columbus for most of her adult life. She had been close to Dorothy in the surface way that proximity enables. She stopped by the house, she ran errands, she was present in the physical sense. But there were tensions. There had always been tensions. Dorothy had, over the years, said things to James that he had filed away without fully understanding at the time. Little observations, small concerns, the kind of things you say out loud once and then decide you were probably wrong about. When Dorothy was diagnosed with ovarian cancer in December of 2017, the family reorganized around her illness in the way families do, with love and practicality and the unspoken negotiation of who will carry how much. James took on the medical role. He researched her oncologist. He drove her to treatment. He kept notes on her medications and her side effects and her appointments and the names of every nurse on her floor. Carol flew up whenever she could manage it. And Renee, who had the most time and the most proximity, became Dorothy's daily caregiver. She moved into the house in January of 2018. She managed Dorothy's medications, she handled the phone calls, she organized the paperwork. She was, by every visible measure, a devoted daughter. Dorothy told people that. She told her pastor, she told her neighbor Linda, she told James. What Dorothy did not tell anyone, not then, not openly, was the thing she was beginning to notice in the quiet moments. The thing she would only find the words for much later, in a piece of paper that no one was supposed to survive to read. In March of 2018, 3 months into Renee's caregiving, Dorothy called her attorney, a man named Gerald Moore, who had helped her draft her will 3 years earlier, and asked to speak with him privately. James did not know about this call. Renee did not know about this call. Dorothy made it from her cell phone while Renee was at the grocery store. She told Gerald Moore that she wanted to make sure her original will was secure. She asked him to confirm it was still on file in his office. He confirmed it was. She thanked him and hung up. Gerald Moore would later testify that Dorothy had seemed, in that phone call, like a woman who was checking on something she was afraid might disappear. He had not understood that at the time. He understood it later. The will that came from nowhere. Dorothy Henderson died on a Wednesday. The official cause of death was complications from ovarian cancer, and she passed in the early morning hours with Renee in the room. James had been there the night before and had stayed until nearly midnight before going home to sleep, and he had kissed his mother's forehead and told her he would be back in the morning. He did not make it in time. This is the kind of detail that lives in a person forever. The way grief plants its flag on the specific, the irreversible, the almost. He got the call at 6:14 in the morning, and he sat on the edge of his bed for a long time before he moved. By the time he arrived at the hospital, Renee had already spoken with the attending physician, already signed the necessary paperwork, already called the funeral home. Renee was organized in the way that people are organized when they have been thinking about logistics for a long time. The reading of the will was scheduled for the following Friday, 10 days after Dorothy's death, in the office of Gerald Moore. James arrived expecting to hear the document he had helped his mother prepare in the spring of 2016, the one that divided the estate equally among the 3 children, with specific personal items designated by name. Carol flew in from Atlanta. They sat together in Gerald Moore's waiting room, and James noticed that Renee seemed unusually calm. Not the calm of grief processed, the calm of someone waiting for something they already know the outcome of. When they sat down in Gerald Moore's office, Renee placed a document on the desk before Gerald Moore could open the file drawer. She slid it toward him and said simply that their mother had updated her will. Gerald Moore looked at the document. He looked at it for longer than a will reading normally requires. He looked at it the way you look at something that does not match the picture in your head. Then he looked at James and Carol, and James said later that Gerald Moore's face was the first moment he understood that something had gone very wrong. The document Renee presented was a typed will. It was dated August 14, 2018, 8 months before Dorothy died and well into the period of her cancer treatment. It bore Dorothy's signature, or something very close to it. It listed 2 witnesses, a woman named Brenda Simmons and a man named Carl Atwood, with addresses in Columbus. It bore a notary stamp from a notary named Patricia Gaines. According to this document, Dorothy Henderson had revised her wishes entirely. The house, the savings account, yet the investment portfolio, all of it, minus a $5,000 cash bequest to James, was to go to Renee. Carol received nothing. The document was clean. It was formatted correctly. It had the right number of pages and the right language and the right signatures in the right places. On paper, it was exactly what a legitimate will looks like. Gerald Moore read it twice, and then he looked at James again, and this time, James understood what that look meant. Gerald Moore had the original will in his file drawer. The will he had drafted with Dorothy in 2016. The will that said something completely different. And now, sitting on his desk, was a document that had arrived from nowhere, that he had never seen, that had been drafted by someone he did not know, and that contradicted his client's stated wishes entirely. He excused himself from the room. James drove home that evening in a state that was not quite grief and not quite anger. It was something more like the dizzying feeling of a floor you trusted giving way beneath you. He had sat across from his sister in that office and watched her face, and it had told him nothing. He called Carol from the car and they talked for 2 hours. They reconstructed everything they knew about the last 18 months of their mother's life. They thought about August 2018, where Dorothy had been, how she had been doing, what Renee had told them about her condition during that period. In August of 2018, Dorothy had been hospitalized twice. The first hospitalization was for a blood infection related to her chemotherapy port. The second was for a fall in the bathroom that resulted in a hairline fracture in her left wrist. James had visited both times. He remembered his mother during those weeks clearly. In August 2018, she had not always been winning the fight to stay lucid. She had been confused on some days. Her doctors had noted it in her chart as a side effect of her medications. James remembered sitting with her on one afternoon during the second hospitalization and asking how she was feeling, and she had looked at him and called him by his father's name. By Robert's name. She had corrected herself immediately and laughed it off, but James had not forgotten it. He had written it down. He kept notes about everything. It was how he was made. And now, sitting in his car outside his own house with the phone pressed against his ear, he pulled out the notebook he kept in his center console, and he found the entry from August 2018, and he read it out loud to Carol, and neither of them said anything for a long moment after that. The signature on the will Renee had presented was close to Dorothy's handwriting, but James had 40 years of his mother's letters, cards, notes, grocery lists. He knew her handwriting the way you know a voice you have been listening to your whole life. He knew the specific way she formed the capital D in her name. She had a habit of closing the loop too tightly, almost turning it into a P, and she had done it for as long as he could remember. The signature on that document had an open loop. It was close. It was very close, but it was not right. He called Gerald Moore the next morning and said 5 words. "I need to contest this will." Before we go any deeper into what James found, and what found him, let us know in the comments where you're watching from. We'd love to hear from you. And if you haven't already, hit that subscribe button so you never miss any of our upcoming videos, because what comes next in this story is the part that changes everything. Digging through the ashes. Contesting a will in probate court is not a dramatic act in the way that movies make legal proceedings seem dramatic. It is slow. It is expensive. It requires a specific kind of stubbornness. The stubbornness of a person who is willing to spend months, possibly years, turning over every document and chasing every lead in the service of a truth that may or may not be provable. James Henderson had that stubbornness. He had always had it. His ex-wife had called it inflexibility when their marriage was ending. His mother had called it dependability when he was showing up for her during her illness. It is the same quality with different names depending on whether it is working for you or against you. In October of 2019, 6 weeks after Dorothy's death, James retained an estate litigation attorney named Patricia Okafor, a Columbus-based lawyer with 15 years of experience in probate and elder law. He brought her the original will on file with Gerald Moore. He brought her the document Renee had presented. He brought her his notebook. And he told her everything, starting from the August 2018 hospitalizations and ending with the phone call Dorothy had made to Gerald Moore from her cell phone while Renee was at the grocery store. A call that Gerald Moore confirmed and that James had only learned about after Gerald pulled the phone records from Dorothy's file notes. Patricia Okafor was, by her own description, not a person who was easily surprised. She had litigated estate fraud cases for 15 years and had seen most of the ways that people find to take from one another when money and grief are in the same room. But when she laid the 2 wills side by side on her desk, she went quiet, in the way that attorneys go quiet when they are already assembling the argument in their head. She noted the date first, August 14, 2018. She pulled Dorothy's medical records, which James had obtained under a HIPAA release signed by Dorothy before her death, specifically because Dorothy had once told James, in one of those small and passing moments that turned out to be important, to make sure he had access to everything. The records confirmed what James already knew. On August 14, 2018, Dorothy Henderson had been a patient at Grant Medical Center recovering from a hairline wrist fracture. She had been administered pain medication and a sedative the previous evening. She had been assessed that morning by a floor nurse and noted in the chart as oriented to person but not to time or place. That was the date on the will. That was the date someone had chosen. Patricia Okafor's investigator located the 2 witnesses within 3 weeks. Brenda Simmons was a 61-year-old woman who had been a casual acquaintance of Renee's for several years. They had attended the same church for a period before Brenda moved to a different congregation. When the investigator spoke with Brenda Simmons, her account of the will signing did not match the document in key ways. She said she had signed something at Renee's kitchen table, not at any attorney's office. She said she had not read the document before signing. She said Renee had told her it was a routine update that Dorothy had requested and that they just needed 2 signatures to make it official. She said Dorothy had not been present. She said she had assumed everything was legitimate. She seemed genuinely frightened by the implications of what she was describing. The second witness, Carl Atwood, you had an address listed on the document that turned out to be a vacant property in Westerville, Ohio. A house that had been empty since a foreclosure in 2017. Carl Atwood, at that address, did not exist. The notary stamp belonged to a licensed notary named Patricia Gaines, who operated out of a small office in the Short North neighborhood of Columbus. When Patricia Okafor's office contacted Patricia Gaines directly, Gaines stated that she had no record of notarizing any document for Dorothy Henderson or for anyone in the Henderson family. She stated that her notary stamp had been reported stolen, along with a camera and a laptop, in a break-in at her office in April of 2018. She had filed a police report. The report was on record with the Columbus Police Department. The stamp had never been recovered. Patricia Okafor obtained the police report. She obtained the break-in documentation. And she sat with those documents and with the medical records from August 2018. And with the statement from Brenda Simmons, and she built the architecture of what had happened. Someone had stolen a notary stamp 4 months before the will was dated. Someone had drafted a typed will using the correct legal format. Someone had persuaded or deceived 2 people into signing as witnesses. Someone had chosen, with intention, a date on which Dorothy Henderson had been assessed as disoriented. And someone had forged, or caused to be forged, the signature of a woman who was lying in a hospital bed that day and would not be alive to dispute it. This was not a crime of impulse. This was a crime of architecture. Whoever had done this had thought about it carefully, planned for the contingencies, and constructed something that was designed to withstand casual scrutiny. What they had not planned for was James. They had not planned for his notebook, his records, his stubbornness, his attorney, or the phone call his mother had made from a grocery store parking lot in March of 2018. And they had not planned for the fireproof lockbox. The lockbox that James remembered. The lockbox that was gone. Because when James had returned to his mother's house in the week after her death to collect some personal items, the lockbox, the gray metal box with the combination dial that had sat on the top shelf of Dorothy's bedroom closet for as long as he could remember, was not there. He had looked for it. He had looked carefully. It was gone. He had asked Renee about it, and Renee had said she didn't know what he was talking about. She had said she didn't recall any lockbox. James had written that down too. The investigation into Dorothy's finances had been running parallel to the will contest since the beginning of October. Patricia Okafor had obtained records for the joint account that Dorothy had added Renee to as a co-signer in February of 2018, 1 month after Renee moved into the house. Over the following 14 months, between February 2018 and Dorothy's death in September 2019, a pattern of cash withdrawals had been made from that account. Not reckless withdrawals, careful ones. Amounts between $4,000 and $8,000, spaced weeks apart, never at the same ATM twice. The total across 19 transactions was $137,000, or every withdrawal had been made on a day when Dorothy was either hospitalized or had a medical appointment listed in her records. Days when Renee's attention would have been elsewhere, or when Dorothy's attention would have been otherwise occupied. Patricia Okafor had seen financial elder abuse cases for 15 years. She recognized the pattern immediately. What she was looking at was not a caregiver managing an estate. What she was looking at was a woman methodically emptying her mother's savings in the pauses between crises, betting that Dorothy would not notice and that no one else would look. James noticed something during this period that he filed away and did not fully understand until later. His sister Carol, the youngest, the one who had received nothing in the fraudulent will, had been unusually quiet since the will reading, a not grieving quiet, thinking quiet. She had been cooperative with Patricia Okafor's investigation, answered every question, provided every document she had. But she had a look on her face in their phone calls that James recognized from childhood. The look Carol got when she knew something she had not decided yet whether to say. He asked her about it once, directly, and she had said she was fine, she was just processing. He let it go. He should not have let it go. But at the time, there were other things to focus on, because Patricia Okafor had just received a phone call from a storage facility on the north side of Columbus. They had found the lockbox. What was inside the box? Dorothy Henderson had rented a storage unit at a facility called Secure Keep Self-Storage on Cleveland Avenue since 1994. 25 years. She had paid the monthly fee automatically from her checking account and renewed the lease every year without fanfare. The unit contained the things that matter to a person but do not have a place in the house. Robert's tools, some boxes of the children's schoolwork she had never been able to throw away, Christmas decorations from decades past, and, tucked in the back corner under a moving blanket, the gray fireproof lockbox with the combination dial. The facility had begun standard delinquency proceedings after Dorothy's death, because the automatic payment had been canceled. Renee had closed Dorothy's checking account as part of settling the estate. This was technically within her authority, but it meant that the storage unit's monthly payment stopped in October. The facility manager, a man named George Tillman, had tried to contact the account holder at the number on file. The number belonged to Dorothy's cell phone, which Renee had discontinued. The second contact number was James's. He had given it to his mother years ago, and she had listed him as an emergency contact. George Tillman called James in November 2019. James called Patricia Okafor. Patricia Okafor obtained a court order granting access to the unit before the facility could proceed with auction. James was present when they opened the unit. He stood at the entrance while the investigator went in, and he did not go in himself for a long moment, because the smell of it, that particular combination of old paper and metal, and the specific dust of stored things, was entirely his mother. He stood there in the doorway of that storage unit on a gray November morning and understood that this was the last room of hers he would ever enter. When the investigator pulled the lockbox out from under the blanket and turned it toward him, James walked in and crouched down and put in the combination. He had known the combination since he was a teenager. His mother had told him. She had told him because she had told him she wanted him to be able to find what was inside if anything ever happened to her. He had thought at the time that she meant if she had a heart attack suddenly, or if she was in an accident. He had not understood, at the time, what she actually meant. He understood it now. The lockbox opened. Inside were the things he expected: insurance documents, the deed to the house, old financial records, a copy of Robert's death certificate. At the bottom, beneath a manila envelope containing their parents' marriage certificate, was a sealed white envelope. On the front, in Dorothy's handwriting, that handwriting he knew better than any other handwriting in the world, she had written 4 words. For James. Don't delay. He stood up and handed the envelope to Patricia Okafor without opening it. He trusted her more than he trusted himself in that moment. She opened it in the parking lot while James sat in her car and watched her read through the glass. He saw her face change. He saw her read it twice, the same way the judge would later read it twice. She walked back to the car and she sat down and she handed it to him and she said, "Read this carefully." Inside the envelope were 2 documents, and the first was Dorothy's original will, the one Gerald Moore had drafted in 2016, signed and notarized legitimately, leaving the estate divided equally among all 3 children. Dorothy had obtained a notarized copy from Gerald Moore's office without telling anyone. She had placed it here, in this lockbox, in this storage unit, as a backup, as insurance against something she had already begun to fear. The second document was a handwritten note. 1 page, written in pencil, undated. The handwriting was shakier than James was used to, the handwriting of a woman in pain, a woman whose hands were no longer fully steady. But it was legible. Every word was legible. Dorothy had made sure of that. In that note, Dorothy described what she had been watching happen in her own home. She described documents placed in front of her to sign that were not explained to her. She described her medications being handed to her in combinations that left her foggy in ways she did not always recognize until later. She described her cell phone being unavailable to her on days when she wanted to make calls. She described the fear of a woman who understood what was happening to her but could not stop it. Not because she lacked the will, but because the person doing it to her was the person responsible for her care, the person who controlled her access to the world. She described the withdrawal of $137,000 from her account in terms that made clear she had known about it, or known enough, or suspected enough. And at the end of the note, in the final sentence of the final paragraph, 12 words pressed into the paper with the careful deliberateness of someone who understood they would not get another chance. Dorothy wrote the name of the person responsible. She wrote Renee's name. She wrote one other name beside it, and she wrote, "I am not crazy. I am afraid. Please find this." James read that note in Patricia Okafor's car, in the parking lot of a storage facility on Cleveland Avenue in Columbus, Ohio, and he did not cry the way grief makes a person cry. He cried the way a person cries when they realize that someone they loved spent the last 2 years of their life frightened, aware, and alone with the truth, and left it in the safest place they knew how to leave it, waiting for him to come find her. The weight of one sentence. The formal probate hearing began in January of 2020. It had taken Patricia Okafor 3 months to assemble the complete evidentiary package: the forensic document examination of the fraudulent will, the medical records, Brenda Simmons's signed statement, the notary theft report, the bank withdrawal records, and Dorothy's handwritten note, which had been authenticated by 2 independent forensic handwriting analysts, as consistent with Dorothy's genuine writing despite the tremor introduced by her physical condition. The other name Dorothy had written in that note beside Renee's was a woman named Gail Watkins, a former co-worker of Renee's who was a notary in the state of Ohio, and who was, investigators would later confirm, the person who had possessed Patricia Gaines's stolen stamp and applied it to the fraudulent will. Gail Watkins, when contacted by investigators in December 2019, had retained an attorney and declined to make a statement. That silence would not protect her as much as she had hoped. The courtroom proceedings were not a trial in the criminal sense. Probate contests are civil matters, but the weight of the evidence made them feel like one. Renee's attorney argued that Dorothy had been mentally competent in August 2018 and had made her wishes known freely and without coercion. Patricia Okafor introduced the medical chart notation, oriented to person but not to time or place. She introduced the testimony of Dorothy's oncologist, who confirmed that the combination of medications Dorothy was receiving in August 2018 could cause significant cognitive impairment on acute days. She introduced the recording of a pastoral visit Dorothy had with her minister, Reverend Arthur Coleman, made in July 2019, 2 months before Dorothy died, in which Dorothy said, plainly, that she sometimes felt confused about things she had signed, that she missed talking to her son, and that she wanted to make sure James would be able to find what she had left for him. Reverend Coleman had recorded the visit as part of his standard pastoral care documentation for his most medically vulnerable congregants. He had not understood the significance of what Dorothy had said until he heard about the will contest. He came forward immediately. Renee's attorney attempted, in the 3rd day of the hearing, to introduce a counter-argument that Dorothy had told multiple people she wished to reward Renee for her sacrifice as a caregiver. Dorothy's neighbor Linda testified that Dorothy had said, on one occasion, that she did not know what she would have done without Renee. The judge acknowledged that testimony. Patricia Okafor acknowledged that testimony. And then Patricia Okafor submitted the phone records from Dorothy's cell phone for the 14 months of Renee's caregiving, records that showed systematically the pattern of calls Dorothy had attempted to make during hospitalizations that had gone unanswered, the calls to James that had not connected on days when Renee had reportedly been managing Dorothy's phone, the calls to Gerald Moore's office that had lasted less than 30 seconds on days when Renee was in the house. Isolation from family and friends is the foundational mechanism of financial elder abuse. It does not always look like a locked door. Sometimes it looks like a busy caregiver who manages the phone for a sick woman who is too tired to notice which calls went through and which did not. The forensic document examiner testified for 2 hours. She had examined the signature on the fraudulent will against 17 authenticated samples of Dorothy's genuine signature collected from documents spanning 4 decades. Her conclusion was stated with the precision of someone who had testified in court before and understood the weight of language. The signature on the disputed will was not consistent with Dorothy Henderson's genuine signature. The loop formation on the capital D was inconsistent. The pen pressure was inconsistent with the pressure Dorothy applied in her authenticated documents, including documents signed during her illness. And the examiner's conclusion was that the signature was an attempted imitation of Dorothy's genuine signature. Close, but identifiable as an imitation by the specific characteristics she had cataloged in her report. Renee's attorney cross-examined her for 40 minutes. The examiner's conclusions did not change. On the 11th day of the hearing, something happened that no one in that courtroom had fully anticipated. Carol Henderson, the youngest sibling, the one who had received nothing in the fraudulent will and who had been cooperating with the investigation from Atlanta, flew to Columbus and asked to give a statement. That statement was the second twist in this story. Carol disclosed that 2 years before Dorothy died, in the fall of 2017, or before Dorothy's diagnosis but during a period when Renee had been increasingly positioning herself as Dorothy's primary point of contact with the family, Renee had called Carol. She had offered Carol money, not a small amount. She had told Carol that Dorothy was planning to update her will and that it would be simplest for everyone if Carol stayed in Atlanta and did not complicate things by getting involved. Carol had not understood at the time that this was a plan already in motion. She had thought Renee was being controlling in the way Renee sometimes was. She had taken the money, $12,000, wired to her account in Atlanta. She had stayed in Atlanta. She had told herself that she was not doing anything wrong, that she had simply accepted a gift from her sister. She had told herself this for 2 years. She stopped telling herself this the day she heard her mother's will read aloud and understood what Renee had actually been protecting. Carol's disclosure included the wire transfer records, which she had preserved. It included the text messages from Renee, in which the arrangement had been discussed. Those text messages were, in the language of estate litigation, substantial evidence of premeditation. Renee had begun planning this before Dorothy was even sick. She had begun neutralizing the opposition before there was any opposition to neutralize. Carol had been a variable that Renee had quietly removed from the equation 2 years before the equation mattered. The fact that Carol had come forward, that she had chosen, at cost to herself, to hand over the evidence of her own complicity, was the act that transformed the civil proceeding into something the Franklin County Prosecutor's Office would read about with considerable interest. The probate judge issued his ruling on February 28, 2020. The fraudulent will was invalidated. Dorothy's original will was recognized as her valid final testament. The estate was to be distributed according to Dorothy's actual wishes, equally among her 3 children. The judge also referred the matter to the Franklin County Prosecutor's Office for investigation into elder financial abuse, will fraud, and theft. What one family's betrayal tells us about all of us. Renee Henderson was indicted on 4 counts in the summer of 2020. Elder financial abuse, will fraud, theft over $100,000, and conspiracy. Or she was convicted on all 4 counts at trial in March of 2021 and sentenced to 7 years in an Ohio State correctional facility, with eligibility for parole after 4. Gail Watkins, whose cooperation had been instrumental in securing the conviction, received a suspended sentence and 3 years of probation. Her notary license was permanently revoked. Carol Henderson, whose cooperation with investigators had been voluntary and who had disclosed her involvement without being compelled to do so, was not charged. She returned the $12,000 to the estate as part of a civil settlement. The judge in the probate case, in his written decision, noted that Dorothy Henderson's decision to place a copy of her genuine will and a handwritten account of the abuse she was experiencing into a secured location known only to her son was an act of remarkable foresight by a woman whose autonomy was being systematically stripped from her. That is a phrase from a legal document, but it means something simpler than legal language usually allows. It means that Dorothy knew. She knew what was happening. She knew she could not stop it from inside the house. And she knew that if she could not stop it, she had to outlast it. She had to leave something behind that would do what she could no longer do herself. What happened to Dorothy Henderson is not a rare story. That is the part of this that needs to be said directly, without decoration. According to research on elder financial exploitation, are roughly 1 in 10 Americans over the age of 60 has experienced some form of financial abuse. The total amount stolen from older Americans through financial exploitation is estimated in the tens of billions of dollars annually. And the perpetrators are not, overwhelmingly, strangers. They are not the telephone scammers calling about Medicare. They are family members, caregivers, people who have been trusted with proximity and with access and with the specific vulnerabilities that come with age and illness and need. The mechanism of what Renee did to Dorothy, the isolation, the document manipulation, the exploitation of cognitive vulnerability during acute medical episodes, and the methodical withdrawal of funds in small enough amounts to avoid immediate attention, is a pattern that elder law attorneys and geriatric social workers see regularly. It is a pattern that tends to remain hidden for exactly as long as the perpetrator needs it to, which is usually until the person they victimized is no longer alive to contradict them. Dorothy defeated that pattern in the only way available to her. She did not defeat it while she was alive. She could not. The power dynamic inside that house during those 18 months had been constructed with precision. Renee had access to Dorothy's medications, her phone, her financial accounts, and her paperwork. She had the legitimacy of the caregiver role, which is one of the most difficult roles to examine critically because the visible work of caregiving is real and demanding, and the exploitation that sometimes rides underneath it is invisible. Dorothy was not naive. She was not confused about what was happening, at least not during the periods when her mind was clear. She was simply unable to act. She was an elderly woman in declining health who was entirely dependent on the person she needed to expose. So she did what she could. She made a phone call from a parking lot. She preserved the correct document. She wrote what she knew in pencil on a piece of paper, and she sealed it, and she put it in the place she trusted most, under Robert's tools and the children's old schoolwork and 30 years of ordinary life, and she trusted her son to eventually find it. There are people watching this video right now who recognize pieces of this story. Not the specific names, not the specific city, but the dynamic. The family member who becomes a caregiver and slowly becomes something else. The parent who seems fine until you look more carefully and realize they have been telling you something for months in the language of small things. A comment here, a concern there, a sentence that you filed away and did not fully understand. The sibling whose behavior started shifting before anyone had a reason to explain it. The documents that appeared and did not quite fit. We are not always in a position to act on those observations in time. James was not in a position to act on them in time. Dorothy herself was not in a position to act on them in time. But Dorothy acted on them in the only time she had left. And that is why the story ends the way it ends. Not with the triumph of a system that protected a vulnerable woman, but with the quiet, extraordinary courage of a woman who protected herself from inside an impossible situation. With a pencil and a piece of paper and a lockbox she'd been paying $11 a month to maintain for 25 years. The Franklin County Probate Court's ruling in the Henderson estate case has been cited in subsequent elder financial abuse proceedings in Ohio as an example of why courts should give weight to evidence of a decedent's pre-mortem awareness of exploitation. The idea that a person who anticipates being victimized and takes steps to document that anticipation has, in effect, provided testimony from beyond their own death. Dorothy's note was not a legal document. It had no formal standing on its own, but it was corroborated, at every point, by the physical and financial and medical evidence that the investigation assembled around it. It turned out to be the connective tissue of the entire case, not because it proved anything by itself, but because it told the investigators where to look. It told them which accounts to pull, which dates to examine, which names to run. Every thread Patricia Okafor pulled had been quietly identified, in advance, by a woman lying in a hospital bed who knew she was running out of time and used what she had left of it to leave a map. James Henderson does not talk about this case publicly. He gave one interview to a Columbus television station after the conviction, in which he said, simply, that his mother was the most prepared person he had ever known and that he was grateful she had trusted him. He said he thinks about the storage unit sometimes, about the fact that if George Tillman had not had his number, if Dorothy had not given his name to the facility manager 20 years earlier, if the automatic payment had gone through and the unit had stayed closed for another year, none of it might have been found. He said he tries not to think about that too much. Carol Henderson returned to Atlanta after the proceedings and has, by all accounts, spent the years since doing the difficult work of understanding her own role in what happened. The ease with which she accepted an explanation that let her stay away. The money she accepted without asking enough questions. The years she spent performing a closeness to her family that was, in reality, distance made comfortable. This kind of accounting is not the same as the legal accounting. It takes longer and has no verdict. The estate was distributed in the summer of 2021. James used his portion to pay off his children's student loans and set aside a fund for their futures. He kept Dorothy's jewelry. He kept her kitchen table. He kept the pencil she had used to write the note, which Patricia Okafor had returned to him after the trial. He keeps it in the same notebook where he wrote down everything he observed during his mother's illness. The dates, the medication names, the hospital visits. The moment she called him by his father's name and then laughed it off. He has not written anything new in that notebook since the trial ended. He does not need to. And the story is complete, but it is complete only in the legal sense. In the human sense, it is the kind of story that does not conclude so much as it continues in different forms. It continues every time a family member becomes a caregiver and the people around them do not ask the right questions. It continues every time an elderly person tries to tell someone that something is wrong and does not have the words, or the access, or the time. What Dorothy left in that lockbox was not just evidence. It was an argument, a 12-word argument pressed in pencil into the bottom of a sealed envelope by a woman who was afraid and who was right and who refused to let the truth die with her. She could not say it out loud while she was alive. She said it in the only way that remained available. And the judge read it twice. Before you go. This one's personal. Stories like Dorothy's stay with you, not because they are unusual, but because, as we said earlier, they are not. Every year in the United States, tens of billions of dollars are taken from elderly Americans by the people closest to them. The vast majority of those cases are never discovered, never prosecuted, never resolved. They end the way Renee intended Dorothy's story to end, with a forged document accepted as legitimate, and a family that never looked hard enough to find what was hidden. Dorothy's story ended differently because she was prepared, because she thought ahead, because she trusted her son, and because her son kept a notebook. If this story made you think about someone in your life, a parent, a grandparent, someone who depends on others for their care, take that thought seriously. Ask the questions that are uncomfortable to ask. Look at the documents. Have the conversations. Dorothy did not have anyone to have those conversations with in time. Maybe someone in your life still does. Now we want to hear from you. Before we go, let us know in the comments where you're watching from. We'd love to hear from you. Whether it's Ohio or Georgia or California or anywhere else in this country, drop your location below and let us know if this story hit close to home. The comment section on videos like this one reminds all of us that these stories are not abstract. They belong to real people, in real places, watching from real living rooms. And we read every single one. Don't forget to hit that subscribe button so you never miss any of our upcoming videos. Because if you thought this story was something, you wait until you hear what's coming next on this channel. A small business, a partner who seemed like family, a set of books that had been quietly wrong for 11 years, and the one accountant who noticed a number that did not add up. That story has a twist at the end that we are still thinking about weeks after finishing it. You do not want to miss it. Subscribe now, turn on your notifications, and we will see you in the next one. Dorothy Mae Henderson, 1946 to 2019. She earned everything she left behind, and she made sure it got to the right people.